party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes. For rebuttal, if you do plan to reserve time, let me know before you start your argument. I'll keep track and we'll keep you apprised. As you can see, you'll be able to keep yourself apprised also.
Except it's on there.
Oh, that's,
It hasn't been working.
oh, really? Well, I will be keeping you apprised.
I'll
Time's
reserve
up.
5 minutes, Your Honor.
Okay. Also, please remember, don't use the names of any children. In this case, we've read your brief and are ready to proceed when you are.
Thank you, Your Honor. May it please the court, Attorney Neil Agrawal for the appellant, the father, Justin Roch. Your Honor, the first assignment of error is really a matter of first impression that I could find almost anywhere in the state. There was very little case law that I could come across, and the state didn't really cite anything. I didn't cite much because, in fact, there isn't much. The question is, in this case, the heart of the case is, if you have an adjudicatory hearing where you're trying to prove parental unfitness on claims of abuse, dependency, neglect, and you're trying to introduce medical records of the child to prove, failure to thrive, medical neglect, whatever, by the parents, there is a statute that deals with the privilege of a patient-physician privilege to prevent the information from coming in. The question in this case is, who holds that privilege for the child? And that is really the heart of the first assignment of error. In this case, the father and the mother argued during the adjudicatory hearing. What happened was, this child is a sick child, has a number of kidney diseases, not through any fault of mom and dad. This is just a medically fragile child. And they brought in the doctor for the child, a nephrologist, I think, which is the kidney doctor. And she testified the child has this condition. The parents objected, first of all, saying, this is all privileged and confidential. It was overruled. She said, why don't you brief the issues? I'll give you a standing objection through all this testimony. Then we briefed the issue, and she overruled and allowed the testimony to be admitted. She found, based upon the medical testimony, found dependency. It was objected to, and the judge basically just issued one sentence regarding this assignment of error. It said, these are the child's medical records, not the parents', and therefore you have no standing. And that was the extent of the analysis by the trial judge. So on appeal, we're not arguing per se whether or not the magistrate properly allowed the medical testimony to be introduced or not. We're debating about who has standing to object, if anyone has standing to object to the child's medical records. In fact, who holds the privilege for this 3-year-old child? Now, in my brief, I tried to list all the possible people that could hold the privilege. First of all, there's the child himself, which is a 3-year-old child. And I'm saying you can't, I think it would be absurd to say only a 3-year-old could come in and stand up in court and say, I object to my medical records, or I give express waivers. So I'm saying that would not apply. Second is you have the guardian ad litem. And the guardian ad litem is not the legal representative of the child. And the statute specifically says, and this is under 2317.02 B1A1, it says it does not apply if the patient or the guardian or the legal representative of the patient gives express consent. And I'm arguing the guardian ad litem is not the guardian, it's guardian ad litem, which is different. It's not the legal representative of the patient. So they have no standing one way or the other to consent or object to the medical records. The third would be who had emergency temporary custody at the time of the shelter care. When a complaint comes in, based upon a finding of probable cause that the child should not be returned back, the court can place the child in temporary custody of Children's Services, can place the child into the temporary custody of a relative. And in this case, the court placed the child into the emergency temporary custody of an uncle. Now, the statute specifically says when somebody gets temporary custody, they are not a party to the proceeding. And the statute says that because we don't want, I guess the General Assembly did not want somebody who got temporary custody to somebody say, well, I'm entitled to an attorney and we can argue with the parents or against the parents. I mean, you are, in a sense, a glorified babysitter for that child while the case is continuing, and you are caring for and providing for the child's basic needs at this time. Then my last person that I think would have standing is the parents. The purpose of the adjudicatory hearing is to determine parental unfitness, whether or not there was a finding of abuse, dependency, neglect. So, if the parent's parental rights are intact at the beginning of the hearing, there's no finding of unfitness until the conclusion, or until, basically the magistrate or the court makes a ruling on whether or not there's a finding of abuse, dependency, neglect. So, if I'm right, the parents hold the privilege, then they have to expressly waive it to have it be introduced into evidence. Here, the parents are objecting throughout the hearing, saying the medical records cannot come in. Now, what is the purpose of the statute to begin with? Why do we have a medical privilege?
Well, before you get into that, let me ask you a question.
Yes, Your Honor.
I don't think you're arguing that nobody could have waived that privilege, right?
No, I'm saying the parents could have waived it.
Okay. And I assume you're not arguing, though, I guess is my point, that the parents exclusively had the right.
No, I'm saying they do have the exclusive right.
Okay, so if a child is abused, a parent can prevent the records of the abuse from coming into court.
Well, well, that was actually I was going to answer that as part of my next. The reason we have a medical statute, a medical privilege, it is to say that, and I'll just use an adult, if you go to a doctor, and let's say you were a drug addict, and you try to get treatment, we don't want somebody to subpoena your doctor to come and say, tell us everything that you and your doctor, the patient discussed with you, because you're going to that physician to have confidentiality, to better yourself, to get treatment, and they don't want, the legislature doesn't want you to turn around and use that against you. That would apply to a child. If a child was injured, whether accidentally or intentionally, and you broke the arm, if you knew, look, if I take the child to the doctor with a broken arm, and the doctor can then you be subpoenaed to come and testify, tell us everything that happened, you are circumventing the purpose of the privilege. Now, there is an exception under 2151-421-83 that says this is the mandated reporter statute. If you are a mandated reporter, as a physician, a lawyer, and you suspect or believe there's child abuse, it says right here, you shall make a report. You shall make a report to Children's Services. So, first of all, that's not what we have here, because the doctor herself testified, and I point throughout, the parents were very loving with the child. They tried to help the child. They took all the concerns seriously. She ordered a no-salt or low-salt diet, and was asked, well, are the parents following? I said, yes, they're doing it to the best of their ability. I watched the patient interact appropriately with the child, the parents interacted appropriately with the child, they were loving, they were caring, but basically, the purpose is, despite the parent's ability to care for the child still failed to thrive, and it was noted that even after the case began, the child was with the relatives, the child also had to go to the ER on a number of occasions because that's the nature of the sick child. So it's not because...
Well, with that statute, though, it's more than just a mandatory reporter. It's a waiver of the physician-patient privilege whenever the child is, if it's suspected that they're neglected or abused, right?
Well, it says right here, Your Honor, it is waived, and the attorney or physician shall make a report subject to Division A1. So it's waived to the extent that you have to make a report. It is not a waiver in a free-for-all waiver that comes in, to be subpoenaed against you, especially when they didn't make a report. We're saying the statute had no applicability. First of all, they never raised it or argued it at any point in lower litigation. But aside from that, The doctor never made a mandated report or argument, but she never thought the child was abused, neglected, or dependent in any way.
Okay, so if that is the situation, then what do you do? Do you have, do you have to go to court and actually get a guardian appointed at that point in time to get the medical records waived? There has to be a way, if a parent is accused of neglecting or abusing their child, you need the medical records. That parent cannot, the parent is by law supposedly acting in the best interest of the child. That's the whole point of all this, right? That's what a parent's supposed to be doing. So if the allegation is they're not acting in the best interest of the child and there needs to be an investigation, a parent can't hold that key. You've got to be able to get it open, the door open some way. So what is your theory as to how the door should be opened?
Well, I think if the legislature wanted like a loophole, they should have put it in there that.
How is that a loophole?
Well, the privilege, I think, is.
If it's for the protection of the child.
Well, the question is, then why would they say that it has to be expressly waived by the legal representative? So the question, I guess, again, back to the basic point of this whole assignment of error is, who is the legal representative at the time of the adjudicatory hearing?
So your answer would be if the court appointed a guardian for the limited purpose of looking into the medical records, then that would be appropriate.
I would not argue, I would disagree with that, because
So you're saying nobody can do it?
I say the person who is the legal representative. Now, if the parents lost legal custody to the child in a prior DN case, and the grandmother had legal custody of the child, and then they subsequently, CSB files a subsequent complaint, then I would argue at that point it's not the parents, it's whoever the legal representative is, the grandmother in that scenario. Okay. So, how much time do I have left here?
I'm so sorry. 3 minutes and 50.
Oh, well, I'll reserve the balance of my time then. Thank you.
May it please the court, Kevin DiMartino on behalf of the Appellate Children's Services. We are asking that this court affirm the lower court's decision with regard to the finding of dependency. Unless there are questions, I'll just briefly touch on what's in my brief, and then I will rest on what's in my brief, which is basically that in a dependency, neglect, abuse case, there has to be the ability for the court to look at the medical records of the child. And in this case, the issue is not who has standing to assert the patient-client privilege. The issue is, did the trial court err in finding that the patient-client privilege belongs to the patient, who is the child? And there's absolutely nothing in the brief filed by appellant or in the case law that says that a patient-client privilege belongs to anybody other than that patient. So the fact that this patient is a child does nothing to negate the case law. In fact, the cases that were cited were all cases where a parent was trying to keep out their records. And Ray Weiland and the LE case, both of those were parents who were trying to keep from the court their own records. That makes a little more sense. And actually, Ray Weiland was legislatively overruled by 2317-02B1B, which was a legislative amendment to take into account the fact that sometimes we need these records. And if it's court ordered through a case plan or an order of the court in a dependency neglect abuse case, then those things come in. So in fact, the legislature is aware and is making efforts to get records that help the child come into the court, either by legislative amendments that the parents' records could come in, or through the statute 2151-421A3, which allows a waiver of the privilege. And it's really ludicrous to say that a mandatory reporter physician who believed a child was abused or neglected could report that to CSB, but then that was just a limited waiver that when they went into court to prove that allegation that was made by that physician, the agency could not use those records.
But here we don't have the physician who's saying the child is abused, neglected, or dependent.
That's correct.
So
So the issue there is this is the dependency case based on the C-section, which is the totality of the environment. So it comes into play because this child has such a severe issue with his, it's a nephrology issue that if not put into remission would lead to end-stage renal failure, and the child can only consume a certain amount of sodium and a certain amount of water. So the environment is at issue and the child's medical needs are at issue. So I think that the patient who would be the one to assert the privilege, which we're getting a little bit astray there, but I think that this physician was okay in, waiving the privilege basically of the child by testifying because it did go to the conditions. And the fact that a mother was incarcerated and father was homeless and had been in and out of jail and had a long history of untreated addiction, including an overdose in July, that those things go to the environment. So even though the statute talks specifically about neglect and abuse and a physician reporting it, once this physician was brought into the proceedings and was asked about the environment, I think that goes to the heart of what the statute is meant to allow, which is a waiver of the privilege so the physician can talk about that child's environment, whether it's, the initial report or subsequent report. So I think it's a little bit of a variation, but I think that that statute still supports the idea that the privilege belongs to the child, not to the parent. And if a parent could come in anytime whether they directly harmed a child or they harmed a child by omission, or they simply were unable due to addiction to even understand that they weren't taking care of their child's needs, and all they had to do was say, I am asserting my child's privilege, you cannot even see their medical records. I mean, this isn't the patient's, this isn't the parent's medical records or treatment records or things about addiction or any of the things that there would be a logical and important, public policy to protect. It's the best interest of the child, which is what juvenile court's main goal is, and they're just trying to find out, does this child have any issues? And the only issue before the court is whether or not the trial court erred in finding that mom and dad lack standing, not all of these other.
Yeah, counsel, getting back to that, when you said that the privilege belongs to the child, well, the privilege may belong to the child, but who can exercise that privilege? A newborn can't exercise the privilege. The law says that a child doesn't have the capacity to make those type of legal decisions.
And I think if the legislature wanted to say a child under age, fill in the blank, that for those, until that age is met, such a person, whether it's a mom, dad, whoever, is the person who would have the ability to make that decision. I think the legislature could put that in. They certainly just amended 23-1702 B1B to put that provision in so that if it's a court-ordered case plan, that would come in regardless of whether the mom or dad waived it. So I think the legislature is aware that there are patients who are too young to be able to have the cognitive ability or even the ability to speak to say whether or not I want to waive the privilege. But I think that what the legislature does is presume that a child would not fight or would not want to, that the child would want to have any documentation come into court that would be in their best interest.
But that goes back to my question to counsel, and that is, the whole point of the parent is the fundamental right of the parent, obviously. And with that goes the idea with our whole society and our jurisprudence and everything else that a parent is acting in the best interest of the child. So wouldn't that mean that if you're going to get records, medical records, if there's no specific statutory exception, which I know you're arguing there is, but if there isn't, then that would mean that it'd have to be a court order or a guardian appointed, somebody that would be able to legally waive the rights of the child.
Or that we just take a plain reading of the statute and say that it's a physician-client privilege and that it belongs to the client regardless of the age of the client, and that if a client is so young that a court or a guardian litem or someone else feels like the court is violating a right or something, then you do in court ask for someone to be appointed. But I think otherwise, we take a plain reading of the statute, which is that it's a privilege that belongs to the physician and the client in this case is a child. There's no exception based on the fact that the patient is a child, and that is therefore a position where no one has the standing to challenge that.
I'm sorry. Go ahead.
And I mean, there are no cases, which means that, to me, that this is something that is being done in all 88 counties where you have a child that comes into juvenile court and there's an issue of dependency, neglect, abuse, any of those things, and the medical records are coming in because the parents, by virtue of the fact that they are in juvenile court, have no longer have the same rights that perhaps they did have before.
But what if you, as a parent, have a child who has a medical condition which you think it's in the child's best interest that the general public not know that medical condition? Would you have standing if someone was attempting to get your child's medical records? Would you have standing to object to that?
In a court context, or do you mean, I guess I don't.
Let's say we're not even in juvenile court, but let's say we end up in court somehow because somebody wants to see your child's medical records.
Right, I guess if there's a subpoena, then you would file a motion to quash the subpoena and put in there the different, the different bases for it. I guess it depends on the circumstances.
Sure, I get that, but you're saying a plain reading of the statute is it's the patient's privilege.
Right,
And Mr. Agarwal, I believe, is saying, okay, fine, but that would be the legal representative of the child.
and in that case, you're talking about protecting the child. So this would be something that would be in the child's best interest to not have that disclosed. So I think in that case, you would have to make a motion to the court to ask that either you be permitted or that on behalf of the child, you be able to make this waiver of the privilege because it's contrary to the health of the child or contrary to the interest of the best interest of the child to have that.
But all we have here is the court saying, after objection and legal argument,
That the parent did not have standing. In this context, so it is in the context of a dependency case in juvenile court. So I would argue that in that case, the court did not abuse its discretion, and this esoteric conversation about who does have standing, I don't think is one that is necessary for this court to get into. It certainly wasn't raised below. The issue is simply whether or not a parent in a dependency, neglect, or abuse case has standing to oppose the patient's, not their own, but the patient, their child's medical records from coming in, especially in a case where it's an issue of the environment of the child in a dependency place under Section C.
Well, I was going to say, the reason why I'm not sure it's necessarily esoteric, the debate, is because if we say that the trial court was wrong and he didn't have standing, and the father had standing, then that leaves the whole situation in flux. So, to me, it's very important as to if we make a determination that the father doesn't have standing, who would have standing? Who would be able to protect that child?
Right, I suppose, the fact of the matter is that it's just, I think that's much more broad than what's currently before the court. I do understand that this will be a binding decision that would have impact, and there would need to be clarity if the court was gonna say, father didn't have standing, but somebody did, that would be necessary. But going through, the guardian ad litem and all those things, I don't think that that's, the issue that's before the court. The issue is, did father have standing? And that's really the end of it. If the court finds that father lacks standing, but the court finds that somebody else should have had standing, that's a different issue. But I also don't think that's the issue before the court. The only issue before the court was whether just father had standing. So
And if we determine the father has standing.
right, then that gets remanded and it goes back, obviously. But the other issues of all these other potential people that, let's say, were not involved in this case, everybody, we could all think of off the top of our heads. I don't think that that's the proper issue before the court right now. It certainly wasn't briefed below. It wasn't something that's even really raised now, other than, as part of his argument and support for why he thinks father should have standing. He's by elimination saying, well, here's 5 people I could think of who you could say could have standing. Since they don't, father must, and that's really not the way to
thing is,
go
I
about
guess,
the analysis.
in my estimation, I'm wondering if it's not an all or nothing. In other words, the court could have said father had standing, but can't because of what the nature of this offense is. It wouldn't be in the best interest of the child to not allow the records to be introduced. That wouldn't mean father didn't have standing.
Right, just
To
not
take up for his child in situations. It's just a matter of whether the court would say, here, yes, you have standing to object, and I'll look at it, and I'll make a determination as to whether or not they should or should not be released.
Sure.
So standing is, that's all I'm getting at. Standing is not necessarily just the end all be all.
Yeah, I agree with that. It's a little bit tougher issue, I think. If there are no other questions, I would sum my brief.
Thank you, Your Honor. May it please the court. Your Honor, page 2 of the judge's decision, this is the third paragraph. The physician testifying was not the father's physician, but the child. The court finds that father cannot assert a privilege that does not apply to him. And that is the heart of this case. Now, the state is arguing only this 3-year-old has the ability under the statute. Well, if we go with that fiction, it says it will not apply if the patient, the 3-year-old, gives express consent. So we go, okay, what is the evidence that the 3-year-old gave express consent to have the medical records introduced? There was none. The 3-year-old didn't testify. The 3-year-old didn't make an argument. No one on behalf of the 3-year-old says, I give express consent. So if we're going to go with the fiction that we're going to say only a 3-year-old holds this, where was the express consent to have it be introduced? And if you read the statute, it doesn't just say a 3-year-old. It says if the patient, which is the 3-year-old, or the guardian, or other legal representative of the patient. So there's 3 parties that can have to expressly consent the waiver. The child, I guess, the guardian, and in this case, the guardian and the legal representative is one and the same. It's the parents. So they have to affirmatively give consent to have it be introduced. So I'm arguing that never happened in this case.
Counsel, I have a couple questions,
Yes.
I'm sorry, but if the court had said that father did have standing, that doesn't necessarily mean that father wins.
No, absolutely
And the
right.
medical records don't admit.
Absolutely, and I agree with, in your colloquy with the opposing side, we're asking the judge should have said, father has standing, but here's why you lose anyways, because this other rule applies, or best interest, or there's an exception, or it's something. But the judge didn't go through any other reasons other than you can't come in the door and make your argument because it's not your medical records. So we're not going to analyze whether or not it was otherwise admissible or not for, if the judge erred in the other way, or the magistrate. So yeah, I'm asking the court simply to hold at this point, father has standing to make the argument, remand it back, and then the judge can analyze under the facts and the law, should the records come in otherwise.
The other question I have for you is because there's error all the time in trial courts. There's error everywhere, but we only deal with prejudicial error, reversible error. And you made a point of saying how everything was so in favor of the child here, that this physician, was not critical of the parents in any shape, manner, or form. So how has your client been prejudiced?
Because both the magistrate and the judge specifically held, because we have a sick child here, and based upon the child's failure to thrive, I'm going to find dependency. And when you read the decision, they specifically cited the doctor's testimony. So it had a factor. And we're arguing if you take out the illness of this poor child, none of the other evidence would rise to a level of...
But nobody's contesting the child's sick, right?
Correct, but they're holding the sickness against the parents in this case. And I mean, that's how I...
But the doctor didn't blame the parents at all.
No, not at all. She thought the parents were terrific. They were very loving, they were very appropriate, they did the best they could. It's just that unfortunately, this child has serious illnesses. And again, to reiterate, the child, when it was after the case was filed, had to go to the hospital a number of times too, in the hands of the uncle and also, again, we're holding prior to the filing against the parents, but subsequent, we're not holding CSB or the relative responsible for the illness of the child. So that's why I don't think this should apply. So respectfully, Your Honor, I'd ask the court to reverse the remand.
Perfect.
Thank you.